Well, welcome everybody. I'm so glad to see you all this morning, bright and cheerful, after a long week. I'm Caroline Fredrickson. I'm the president of the American Constitution Society for Law and Policy. And we're here this morning to discuss the Affordable Care Act and the 3 very long days of argument that was a little dramatic flourish. Very interesting arguments in the Supreme Court and some very, very significant constitutional and other legal issues that were discussed. Now, I think most of you here are familiar with the American Constitution Society and the role that we've played in the Affordable Care Act from well before the bill was actually signed into law by President Obama. Our interest is not per se in health care, but really in the approach to the Constitution that has been raised by the opponents of this legislation. Their view that the Constitution itself, the Commerce Clause particularly, is a limiting principle, and that Congress has very little ability to address national problems. So for the American Constitution Society, we believe that there are enduring and important principles in the Constitution of due process, liberty, equality, justice, and these principles are threatened by the approach that the conservative legal movement has raised to the Constitution. And so we've engaged in the Affordable Care Act in that way. We published an issue brief by Simon Lazarus called Healthcare Lawsuits: Unraveling a Century of Constitutional Law and the Fabric of Modern American Government. And that pretty much sums it up. We've done quite a bit of work. We've done briefings on the Hill and with the media. We have held events around the country throughout the process and consideration. And we continue to work to educate the public about the significant issues, and particularly this very, very radical approach to constitutional interpretation. So the Affordable Care Act is not just about this particular piece of legislation that was addressed by the Supreme Court, but about the progressive vision and the conservative vision of the Constitution. Certainly, addressing the minimum coverage provision that's an issue where the Supreme Court will grapple with the very ability of Congress to address national problems. Medicaid, the Medicaid expansion, we'll consider whether the government can actually cover our poorest citizens and provide them with health care. And we'll examine the relationship between our state and federal government. There's the Severability Clause, which of course was the subject of frivolity, as Chief Justice Roberts called it yesterday, which I think maybe puts Supreme Court justices in a special category of human being when they find that subject so amusing. And then the Anti-Injunction Act, which was the first day's discussion, which I think we probably won't spend a lot of time on because it's rather esoteric and nobody really wanted to talk about it. So, but then of course, you know, the constitutional questions are important, but the policy issues are exceedingly of interest to Americans. And for those of us who live in Maryland, last Monday, Maryland established 2 health care exchanges to expand access to insurance under the reform. And the Affordable Care Act has already, since it's been passed, worked to address racial, ethnic, and income disparities in our health care system. So this morning, we have a panel of speakers who are extraordinarily well qualified to discuss the Affordable Care Act and well, we won't call it the aftermath. That sounds too negative. I'm not ready to concede anything yet. But the impact, the discussion in front of the Supreme Court that happened this week. And so I'm very privileged to be here with Walter Dellinger, who's the former Assistant U.S. Attorney General and an acting U.S. Solicitor General in the Clinton administration, and is currently a partner here at Melveny and Myers, where he's chair of the appellate practice. And I want to thank Walter and Melveny for helping us get this wonderful space. We're also privileged to be here with Doug Gansler, who's the Attorney General of Maryland, and was the lead author of the brief for the 11 states in favor of the Affordable Care Act. And finally, we have Maya Wiley, who's the co-founder and president of the Center for Social Inclusion, where she works as a civil rights attorney and policy advocate on issues of race and poverty. So we're going to have a discussion up here for about 40 minutes, and then we hope that have an opportunity for all of you to join in and ask questions of these extraordinarily informed individuals. And I'm going to start with the former Solicitor General to give us a broad sense, a dramatically broad sense of how the week went. And sorry for the feedback here. We'll correct that. Someone is interfering with this discussion. Yes. So, I mean, I think the question I want to ask you, Walter, in some sense was, people have suggested that that the questions were pointed, that the tone was tough, but it seems to me, not being the expert that you are, that actually the questions that were asked were exactly the questions that had to be asked, because those are the questions that were raised in the briefs, and those are the questions that have been raised by the conservatives. And so it seems to me that the justices were asking those questions. Am I wrong?
Only partly. That is, I thought some of the questioning indicated a lack of familiarity with the government's brief that I found very disappointing. Can I take a few minutes to give an overview
yes, please do.
Of what I thought went on with the argument? First of all, I think the outcome of the adjudication on the mandate is not possible to determine based on the oral argument. I think Justice Alito did demonstrate through asking every single question that he asked was hostile to the act and was nearly as combative as Justice Scalia, that I think that there appear to be 3 justices who would invalidate the mandate. If there were 5, and I said the outcome is indeterminate, but if there were 5, I would be shocked, because I think it would take us back to the jurisprudence of the 1920s. I think it would be the most stunning and indefensible judicial decision in half a century. It would be paired with Bush versus Gore in the law books forever. And I will say a few words about why I think that's the case. First, the oral argument. I went through the transcript again last night. The Solicitor General, Don Verrilli, I thought did an excellent job. If you read the transcript, you can see that he stated the case for this act. He stated it clearly. He defended it. He made all of the essential points that he wanted to make. He did the excellent job that an advocate needs to do of returning time and again to the central themes, and he stated the limiting principles that should allay any concerns about sustaining this law. Let me note in particular the concerns that were raised by the Chief Justice and Justice Kennedy, each of whom could be evoked to sustain the mandate, and I want to address the concerns that they expressed. I think probably the single most important and positive note that came out of the oral argument was the fact that the Chief Justice repeatedly throughout the transcript kept coming back to the fact that this is not a regulation that forces people into commerce. It is a regulation of commerce in which people will inevitably and involuntarily engage, and that is in healthcare. I was struck reading the transcript, even though I had been in the courtroom, how many times the Chief Justice during arguments by Mr. Clement and Mr. Carvin, when they would say that this is Congress requiring commerce in order to have something to regulate, kept saying that is not the government's argument, counsel. The government's argument is that this is a regulation of financing health care in which individuals will inevitably engage. I think there was really only one contrary question raised about that might have concerned the Chief Justice, and I want to address that. And that was the notion that within the package of the minimum insurance coverage are matters of preventive care. That is, it covers mammograms, it covers pap smears, it covers as well as maternity coverage, pediatric care, that the government's defense was attacked first by Justice Alito on the grounds that even if you accept the government's position, the position to which the Chief Justice kept referring, that this is a regulation of commerce in which people are going to inevitably engage, that there are aspects of this in which people will not inevitably engage. People can choose not to engage in preventive care. And to that extent, the law does force people to engage in commerce which they could, and some would, choose not to participate in. The answer to that from the Solicitor General was he gave in the time he had before the next questions came. He gave the first and I think foremost answer to that, which is that the construction of the shape of the package is clearly a policy judgment for Congress. Once you have decided that this is itself a regulation of commerce in which people are inevitably going to engage, the fact that you create a package is a policy judgment that the court shouldn't dismember. There is an additional reason why it is necessary to include preventive coverage. It fits within the heart of the government's defense. And that is the fact that if you provide funding for catastrophic care and not for any of the preventive elements, you create a perverse incentive in which people will wait until they have a chronic or an acute and desperate condition that needs extraordinarily expensive care, so, in order to seek that care. So that if you set up a system in which you do not fund mammograms, but you do provide the funding for mastectomies and treatment of metastasized breast cancer, you're setting up a system that has a dysfunctional feature. And so Congress surely could and necessarily did say, we're going to make sure that 30 million additional Americans have coverage for health insurance, but we can't have it where we want them to wait until it's going to cost hundreds of thousands of dollars to be treated instead of providing for the kind of preventive care. And once you put it that way, I think that answers the Chief Justice's only possible caveat to his clear recognition that this is not a requirement that creates commerce that wouldn't exist, but a regulation of commerce which will inevitably and involuntarily exist, and which includes preventive care in a way that is necessary and proper to the fulfillment of that larger goal. So it's a minimal necessary and proper argument. So I think that is the response to the Chief Justice's concern. Justice Kennedy seemed clearly to recognize that this was, as he said in questioning Mr. Carbon, Justice Kennedy recognized, he said, that this is proximate, very close. If it's not commerce, it is just, one step away. It is. It was the widely quoted remark that it is proximate to the to that commerce. Oh, I'm sorry. It's at page 104 of the transcript. I think was, in a sense, to me, the single most important moment in the argument, where Justice Kennedy says, most questions in life are matters of degree. In the insurance and health world, both markets stipulate two markets. The young person who is uninsured is uniquely, proximately very close to affecting the rates of insurance and the cost of providing medical care in a way that is not true in the other industries. That's my concern in the case. The other aspect of it one would want to address for Justice Kennedy is that he seems to have substantive due process concerns that keep sort of entering into the back door. And I think in that case, Mr. Carvin should have, or Mr. Carvin's argument should have exacerbated the concern the courts had that this was a new version of substantive due process. He kept talking about taking from A, the property of A, and giving it to B. These are substantive due process concerns, and that have no place in a case whose central question, after all, is whether this is within the scope of the phrase commerce among the states. And it loses sight of the fact there's a very simple question here. Is this requirement to purchase life insurance, to purchase health insurance, is this requirement to purchase health insurance within the scope of commerce among the states? Judge Silverman said, of course it is. And he would say any requirement that you purchase a product is within the scope of commerce among the states, and that's the only question presented. And Judge Silverman said Congress would rarely use that authority. So I think it is important to frame the case that you start out with a presumption that this economic regulation is commerce within the states. And then you acknowledge that if the court disagrees with Judge Silverman, a highly respected conservative judge, that this is purely and simply a regulation of commerce among the states. If you accept from that those requirements that people purchase a product, mandatory purchase requirements, the limit of that has to be, as the government has argued, that it wouldn't extend to those purchases that are inevitable. And if you look through the transcript, the limiting principle, if you don't want to agree with Judge Silverman, and you want to say that you cannot exclude from Congress's authority the regulation of this aspect of commerce when there's going to be inevitable purchase, you state the limiting principle. It comes through the argument in every piece that the Solicitor General makes. We are talking here, and all the court needs to hold is that the power to regulate commerce among the states extends to the regulation of those purchases which are inevitable, of goods and services which will be provided to the individual even if they have made no arrangements to pay for them, where the costs will be shifted to others in a way that undermines an undoubtedly constitutional regulatory scheme. And those are the elements of a principle the court could adopt and say, if there is some reason to excise from commerce among the states those regulations of commerce among the states that include regulation of purchases one hasn't yet made, that exception can extend to circumstances in which acquiring the product is inevitable and involuntary. The product will be provided whether you've arranged to pay for it or not. The cost will be transferred to others, and the result will be to undermine the effectiveness of a conceitedly constitutional regulatory scheme. Those elements of the limiting principle exclude virtually every single hypothetical that was asked. And if there's anything out there that meets those requirements, then yes, Congress could regulate that too, in the same way of providing an incentive to engage in commerce. So I think the outcome of this case is by no means determined. And I think at the end of the day, it would be shocking to see the court second-guess the judgment of Congress. And in that way, I thought the severability argument reinforced strongly the notion that the court should defer. When the court could not understand, why are we going to be eliminating the provision that says insurance, that children can stay on the insurance policy until they're 26 of their families? Are we eliminating preventive care funding for low-income people for their medical coverage? What all are we eliminating, and how is it interrelated? One of the things it showed is when I read the severability argument, I thought, this is why courts have stayed out of second-guessing economic regulations. It's not like asking whether the principle of liberty extends to same-sex unions. It doesn't involve these complex budgetary and economic calculations way beyond the capacity of those 9 people sitting on the bench with none of the resources to study and analyze these problems. And that's why, beginning with the rejection of the old conservative court of the 1920s and 30s, courts have stayed out of trying to second guess what are economic regulations. Nothing in the submission, and this I think will comfort Justice Kennedy, nothing in the submission made by the government touches the decisions in Lopez versus Morrison about guns near schools and violence against women. Non-economic regulations. This is purely and simply an economic regulation. And it gets into an extraordinarily complex issue. So I think that whatever the court was thinking on Tuesday, when it saw Wednesday, Wednesday gave it an opportunity to go into the complexities of the statute. And I think we will hear more of that from Maya. And then Doug, I want to know how the state attorneys general will feel if they succeed in taking away prescription drug benefits from every senior citizen in their state.
Yeah. Well, thank you, Walter. That was very insightful and helpful, I think, to set the stage. And actually, I was thinking, Doug, that you know, you provide a good example of sort of how the costs are shifted, and perhaps what the role in the interest of the state of Maryland is. But I was so interested to find out as a resident of Maryland that in 2009 there were $999 million worth of uncompensated costs that I guess is part of what I was just paying in my taxes. So it's obviously something of great interest to all of us. And so if you could talk a little bit about how Maryland got involved and sort of what's at stake for the states.
Okay, thank you, and I guess this is working. So, I didn't bring any notes because I thought Walter would go the whole 40.
I'm trying to.
I thought Walter would go the whole 40. I've seen his shtick. He has also do a lunch for the National Association of Attorneys General meeting every year, and it's very well attended. It's a sellout every year, and it's incredibly entertaining and very thought-provoking. So I found out I was doing this with Walter, and I feel like I argued one case in front of the Supreme Court. I've seen one case argued, and that's it. And so I feel like the guy who sort of went and watched the Washington Nationals game once, and then they say, go play. So I will mostly defer my comments. But Carolyn and I went to Yale at the same time, and I was there for lacrosse, and she clearly wasn't. So I'm going to, before I get to, she was there, she was smart, right? So before I get
I ran track.
Oh, you did?
Yeah.
Oh, so
That's so smart.
we had loops around us when we were practicing. So
I didn't know we were having an affirmative action conversation.
Yeah, I am an affirmative action child. So I'm going to be a little bit more of a lacrosse player. Before I get to the answer to your question, we do what Walter did, just give my little overview. And then sort of gets into how we got involved. Walter said it's a very complex issue. I find it less so. I think if you look at the Commerce Clause, it says to regulate commerce among the several states. It's right here in the little Constitution book they gave us. And nobody has argued that the healthcare industry and the national health insurance industry is not interstate commerce. The question becomes whether they can mandate you to participate in that. But really no one's taken the view that that isn't interstate commerce. 18%, almost 18% of our gross national product. We spend, just the enormous amount of money on that. So it would seem that clearly it's constitutional unless you don't want it to be. And if you don't want it to be, it's because you're doing what has been so much of the debate, I think, on this issue. There keeps being a blurring between whether this is whether the Affordable Care Act is a good thing or a bad thing, as opposed to what should the Supreme Court decide in this case based on its own jurisprudence and the Constitution. It reminds me, I work at the U.S. Attorney's Office here in the District of Columbia, and Eric Holder was my boss at the time, and at the time they were discussing, there was drive-by shootings, I'm a little older, than I might seem. And there's a big drive-by shooting thing going on here in DC. And somebody wanted to make, Eric Holder wanted to make, along with other people, tinted windows on cars, get rid of those, to ban those in the District of Columbia, because that's how people were doing the drive-bys. And people said, that's unconstitutional. And at one point he said, I looked through the Constitution last night, didn't see anything about tinted windows, right? And so it's really subject to interpretation in so many ways, but this seems quite clear that it's interstate commerce. So then you go to the next level, which is under its own jurisprudence, under its own cases, is there a distinction between activity and inactivity? Or is that a false choice that's being set up by the opponents of this? And I would submit it is. And the two cases that we cite in our amicus brief are Wickard, which is a 1942 case, and Rodriguez, I think it's Rodriguez 2005 case. And the Wickard case was about someone growing wheat in Iowa and didn't put it on the market. It was for his own consumption. And then Justice Scalia, I guess in 2005, wrote the case about marijuana for consumption. And the issue there was, well, if everybody did that and nobody put it in commerce, that would affect interstate commerce. So they said the Commerce Clause could cover that. And it seems like that this is directly analogous to that. And it's certainly hard to make a distinction between the activity and inactivity, except for you could arguably go through your life without smoking pot. You could go through your life without eating wheat. My wife's on a gluten-free deal right now. And people have said, well, if they're going to regulate the healthcare industry, they're going to regulate broccoli, right? Keep your broccoli. My 15-year-old son to this moment has never eaten a piece of broccoli and could easily go the rest of his life without doing so. But as Walter mentioned, the argument, you cannot avoid the healthcare system. You were born, you were in it, for the most part. Almost all of us are midwives. So it's a very, it seems to be a quite easy resolution. And then you go, and I know it's not the Commerce Clause, but the question is, how is this an issue of national import? How different is this than broccoli? And other than the fact that it's 18% of our GNP and it's dragging down our economy, then you go to the other things the Supreme Court has said are okay, or the Congress has said okay and it's still valid, which is paying our Social Security, paying our income taxes, truck drivers on the interstate highways having to have insurance, sending your kids off to war to die. These are things that Congress is allowed to do and they're constitutional. Clearly they can make you get health insurance. So I look at it from the lacrosse player's perspective that it's quite simple. And the Congress, if they had integrity, if the Supreme Court had integrity involving its own jurisprudence and what the Constitution says, then it would be a 9-0 vote. But this is a court that has done good. Bush v. Gore and Heller and some other cases that seem to be tortured in its reasoning. I don't think, though, that the justices are going to make decisions based on politics. I don't think they're going to say, well, this is going to help Mitt Romney, this is going to help Barack Obama. I think they're going to do it on ideology, but not on politics. And then the last point I want to make is sort of the importance of Maryland and other states. And you mentioned the $999 million in unfunded payments. Every family in Maryland, the average family has $1,000 higher premiums in terms of their insurance to compensate for uninsured people. Every time you go to a hospital in Maryland, you're paying an extra 7% on your bill to pay for uninsured people. So it really is, it affects us all, and it's sort of interesting how this came out as a Republican versus Democrat issue. In our states, we wrote the brief on that, the issue of the mandate, and 11 states were on that. All 26 Republican states were on the other side's brief. Even Ken Cuccinelli, Virginia, I think, joined on at the end. We had a discussion about this very issue last night. The other states that didn't join our brief did so because they're Democratic attorneys general that believed in our position but were engaged in elections in red states or felt that would be politically disadvantaged to do so. They're all sort of with us on this. But it clearly does affect the states. So I don't think they should look at the effect of whether it's a good bill or a bad bill and how it's going to affect the states above and beyond the fact that it will have an effect. Congress has passed a law because they believe it to be a good thing, and that Medicaid would suffer significantly. And that's, and the arguments there seem to be reversed. Saying we like this, the federal government has the authority to do this, you can't take that away from us. So they kind of took the other side of the same argument. So with that, I will subside and pass it back to you.
Thanks so much, Doug. That was very, very helpful to the discussion, and I'd say there was a little more than lacrosse going on, obviously. You're going to Yale. But my, so this is, obviously a very significant piece of legislation, and a lot of people, we've talked a lot about the sort of the costs of providing for the uninsured, but looking at it from the other side, let's talk about the benefits. There are a lot of people who have not been able to afford preventive care. I mean, who are forced in some sense to use only emergency care because they can't afford to do anything beforehand. So, in a sense, there's a compulsion on that side about how they've engaged themselves with the healthcare system. So, can you talk a little bit about, from your perspective, what are the benefits and how important is it to make sure that there's some access to this kind of broader health care rather than just the emergency room that's available now?
Yeah, I'm happy to, and it's a pleasure to be here. I only came because I could sit next to Walter Dellinger, so I'm sorry about that, Caroline, but that's God's honest truth.
I'm here too, for the same reason.
The benefit to being the attorney on this panel who actually works directly with community is that, when we're looking at the kind of arguments that we've been witnessing over the past 3 days, we can come at it from the perspective of what this is really about, right? Because what this is really about is whether everybody can see a doctor when they're sick. That's really what this is about. And that, I think, the biggest tragedy of the past 3 days is that's not what we were talking about. It's not what we were talking about. From a legal perspective, I think Walter stated it quite clearly. But this is what this legislation is fundamentally about. And when we look at what that represents, particularly in light of the communities that it impacts, let's remember that a couple of things. The way this market works, most of us are one paycheck away from not being able to see a doctor. And there are far too many of us who are actually working who are not actually even able to transact in the healthcare market because our employers are not providing insurance. Often because the employers can't afford it, right? So this isn't about exclusively about good employers versus bad employers. This is about the fact that the market itself is not functioning in a way that ensures that we can all see a doctor when we're sick. So that's fundamentally what this is about, and I wanted to ground that. What the Center for Social Inclusion did largely was focus on 3 states on implementation of the Affordable Care Act to ensure in particular that communities of color and low-income white communities would actually benefit from the implementation at state level. And the 3 states that we worked in, we did not work in Maryland. We worked in 3 states that are appearing on the wrong side of this argument: Mississippi, Louisiana, and Texas. So let me give you just a little snapshot of what this legislation means in these states that are opposing, in my view, everyone being able to see a doctor when they're sick. One is Texas, one of the highest uninsurance rates in the country, 24%. 24%. And if we break that down, Louisiana, 20%. 20%. 1/5. Now you tell me how, really, I'm not an economist, but you tell me how, since Clinton, this conversation has also been about the economy, right? So morally, yes, it's about being able to see a doctor, but fundamentally we've been trying to fix it because of the economy. These are the states with some of the biggest economic crises in the country. And part of it is because of healthcare costs and the fact that 20 to 24% of their populations are uninsured. And Mississippi, let's look at this by race. Mississippi, 22% of black people in the state do not have insurance. 22%, and they're 36% of the state. Okay? 20% of Latinos in Mississippi and 17% of white people. So that's crazy. So when we start to talk about the severability argument, just the severability argument alone, the idea that we let this whole thing go down, I agree with the legal arguments, obviously, on the individual mandate. But if we let this whole thing go down on this point about whether the whole, as Scalia said, the whole thing has to go down on this, then what we're really saying is that up to 1/5 of the population of some of the states that were on the wrong side of this argument are not going to be able to see a doctor when they're sick. And I want to raise a couple of other issues that are critical to this, because the other part of that happened in this argument is we lost so much of the actual impact of this legislation on people's lives. Because in addition to it being about the individual mandates and how we're actually paying to ensure that the economy of this works, is community health clinics. We have so many communities, particularly in the states that we're talking about, where people do not have access to a doctor outside of getting a community clinic. And it was providing huge amounts of resources to this. Increasing doctors who will actually serve communities that don't have them. That was a part of this legislation. And unfortunately, because we still have racial boundaries in this country, geographic and psychological, it is the communities that have the highest rates of lack of doctors, unfortunately, are communities of color and rural white communities. And these are the places that most need the provisions that ensure that people of color and people from rural areas who are most likely to go back and serve these communities are actually getting to and through medical school. That's part of this legislation. And in addition, data collection, okay? How are we doing? I mean, isn't it a fundamentally important thing that our leaders understand the impacts of what they've done? And that in a democracy, we're actually able to understand it and debate what's working and what's not working. It's a fundamental part of this legislation. So unfortunately, the conversation and the arguments themselves, as important as they were from an intellectual and legal perspective, and I think disturbing, frankly, particularly from the questions from some of the justices, was that really fundamentally this is about whether the leaders of our nation that we elect locally are able to try to solve some of the largest problems our society has to solve, and the Supreme Court should not tell them they can't, not in this instance.
Thank you so much, Miley. There's obviously, Maya, there's a lot of food for thought in what you've said and what the other panelists have said. I want to, we'll shortly open it up to questions, but I wanted to tease out a couple of other things. And I think Doug had mentioned the Reich case, and Walter, I'd love it if you could sort of explain a little bit what you think Scalia was suggesting in his question, whether he sees a distinction between the homegrown medical marijuana and why you can regulate that as being having an impact on interstate commerce, but somehow regulating the healthcare industry doesn't affect interstate commerce. Can you pull that out for us?
I can't. I truly don't understand the distinction. But Maya's, very informative presentation of what would be at stake when this law is passed stands in stark, what we have learned that we will lose if this whole bill goes down stands in stark contrast to the questioning in the court. I was struck by how callous some of the questioning was. It's really quite striking. When the Solicitor General notes that a critical part of the background against which Congress is legislating is the obligation we have to provide treatment to people who are sick or injured. The snappy reply from Justice Scalia was, well, don't obligate yourself. And that the background fact that we do provide treatment to people whether or not they can afford it was said to be, quote, a problem created by the government, by Justice Scalia. That it's a problem that we don't let people suffer and die on the steps of the hospital. The notion that that's a problem of the government's creation is fundamentally callous. And in fact, it's not even correct. There is a federal statute that requires emergency medical treatment for those who receive federal funds. But many of the states who have brought this litigation have similar explicit laws in their own states. And the notion that this is a problem of the federal government's creation ignores the fact that there's a 1,000-year tradition in the medical profession of providing treatment to the sick. And one aspect of this that is beyond the appropriate skill set of justices on the court are the overall economic implications. Even if you don't care about the social justice of treating the sick, there is the fact that our present system has an adverse effect on our entire economy. Because we don't provide preventive care, because we don't have insurance for so many tens of millions of Americans, many are going without care. Many are using expensive hospital emergency rooms as a provider of first resort, and many are waiting until problems are critical and extraordinarily costly. The cost of this is being paid by other insureds, is going into the cost of the insurance that is provided as part of the employment of people in the workforce, raising the price of American products and interfering with competitiveness. This is a complicated attempt to ensure this, and the court, I think, indicated at several points that it is simply out of its depth in understanding the economic interrelationships here, and why this particular regulation of inevitable commerce is valid. Let me just say one more point. I think that the court's notion that this is getting back into substantive due process, which was a discredited notion where a conservative court at the turn of the 20th century invalidated what it saw as social legislation that had redistributive effects. Though that court stepped back from the brink and didn't invalidate Social Security, but it did invalidate other laws. And it's clear that Mr. Carbon was expressly inviting the court to return to that era. And that, I think, the Chief Justice Roberts expressed concern. When Mr. Carbon said it is no part of the Commerce Clause to promote commerce, the Chief Justice asked him, how could that possibly be? My question would be, does that mean the Department of Commerce has always been unconstitutional? Their entire function is to promote commerce. And the notion that, and I think one of Don Verrilli's best moments came in page 35, where in his wonderful understated way, he responded to the argument that there's a subsidy going on here from the young and healthy to the older and sicker, by saying that this is the Solicitor General at page 35. This is the Solicitor General. It would be unusual to say that it is an illegitimate exercise of the commerce power for some people to subsidize others. He noted that's what our telephone rates did, set by national regulation. The dairy price supports transferred money from people in the cities, often low-income people, to more affluent dairy farmers. And they were upstate. Now, this may be a very bad economic policy. I happen to think it is, but the court says that's a judgment to make in terms of regulation of commerce. So the notion that when you're regulating commerce among the states, you have to watch out for subsidies. And you have to be concerned that not everybody, because some of them are men, not everybody is going to need mammograms or maternity care. You know, it's really shocking. If it were the case that we as a society want to make women bear the special burden of what they do to keep our human species going and to raise our families, that we have to make sure that they bear the entire cost of that, and that it's not covered by insurance is itself a callousness that showed through at several points in the argument.
Yeah, can I just make
Yes,
so? I told you. So just one thing we have, just to this Commerce Clause point, and the whole, and Ginsburg said this very, very clearly in the argument, this is like Social Security. And there were several references at various points of time to the New Deal. So one of the things historically we should remember is that the one piece of New Deal legislation that did not happen was healthcare reform. And Truman tried to do it, President Truman tried to do it again in the early 1940s. It got shot down. And the reason it got shot down was not because the Congress was worried about the Commerce Clause. It got shot down because southern states did not want to integrate health care. And health care reform would have necessarily meant the integration, the racial integration of the healthcare system. All right, now I'm just sharing that as history because to the extent that there is discussion in the arguments that suggest that the things we did in the New Deal were fine under the Commerce Clause, that we tried to do something much more radical back in the 30s and 40s around healthcare than anything this Congress did in this current bill, in this current piece of legislation. So I think we should remember that. And just to the point about the economics of this, and the other thing to remember from a Commerce Clause perspective is no one state could solve the economic impacts of this alone. No one state could solve the economic, I mean, Maryland can solve this by itself? I mean, that's why we have a federal government, right? And that's why we have a Commerce Clause. And just to put this in some economic, both moral and economic terms, and I'm just focusing on the impacts of racial health disparities here that this act starts to address. Closing racial health care disparities gap would save 84,000 lives. I'm not talking about length of life, I'm talking about life or death.
Per year? Or what?
Per year. Secondly, the annual cost of those racialized health disparities is estimated at $415 billion. Billion. All right? Sound like an economic issue?
Both Maya and Walter said most of what I was going to say, but I would, in terms of arguing for this, I mean, as Maya was talking, I was thinking, well, obviously that's why they passed the Affordable Care Act, because there's all these issues out there. There's 40 million people uninsured, we're paying for them anyway, and it's going to be savings, and we're going to save lives and dollars. The case I argued in front of the Supreme Court was about a father who molested his own child when he was 3 years old. The case was about invocation of counsel and how long that lasts. I was told when you go up there, don't talk about, I've been a prosecutor for 20 years, don't do the, this poor child's been molested, kind of go to the substance of it, talk about the law. The only reason why what Maya was talking about would be relevant, I would argue, to have had more discussion about in front of the Supreme Court, given that there was a lot of time in this particular case, was because of exactly what was mentioned. It took 78 or 80 years. They've been trying to do this since FDR. And the argument that keeps being made, well, what is the limit? If you allow this, what is the limit of Congress's commerce power? And the reality is there's nothing like it. And the only other analogous, and this is Walter brought it up, the only other analogous situation is Social Security. When there was a crisis in the country regarding the poverty of the elderly, and that something had to be done, and the states couldn't do it by themselves. It was interstate in nature and by definition, and that's when they passed the Social Security Act. So I think that the backdrop of why they did this and the effects it has both from a moral and an economic standpoint would be relevant because it would show that this isn't really likely to happen next week when they're going to start regulating broccoli.
Thanks so much to all our panelists. And I would say, what you all make me think is that in so many ways the question has been so ill-framed in the broader discussion that the issue really shouldn't be if Congress can do this, what else can it do? But if Congress can't do this, what could it possibly do? It seems like the most essential problem, certainly one of them facing our nation. So we have some time for questions. And so we'll start with the media. You want to identify yourself?
Hi, I'm Kim Atkins from Lawyers USA.
If there's a microphone.
Oh, sorry. Thanks. Kim Atkins from Lawyers USA. Sort of spinning off that point, one thing that I thought was very interesting was when Justice Scalia basically said, no matter how we rule, the congressional process will never be the same after considering this. Can you talk a little bit about the effect that it will have on Congress? I mean, any legislation, certainly one of this size, lawmakers are not drafting it with the Commerce Clause in front of them. There's a lot of deal making going on. There are things that are going in, things that are going out. It's a product of compromise. So would it mean essentially that no major large piece of legislation would be able to pass because you could not guarantee that every aspect of it would pass a Commerce Clause evaluation?
I do think there would be a problem for Congress in that the doctrine that this somehow is outside the scope of the regulation of commerce among the states is an argument that was, I think, so novel that Congress would not have anticipated at the time that it was passing this legislation. I mean, this was a law based on adopting an approach to providing health care that was more conservative in that it used the existing private market and gave people an incentive to have coverage in order to make effective the prohibition on turning people down. I mean, nobody would have thought that raised a constitutional question, so that in that sense, Congress was, I think, would be blindsided. What strikes me as the consequence, if the court were to hold the mandate as unconstitutional and that the entire bill goes down, the immediate consequences would be enormous. The pressure on Congress to come up with some emergency solution would be enormous. I think the effect on I think the 26 attorneys general who brought this litigation, if the entire bill were invalidated, would be in the position of the dog that caught up with the truck. They would no longer be proudly proclaiming that they were involved in bringing this litigation. No attorney general is going to want to say, it was my litigation that today resulted in the fact that you may now lose your health insurance if you have a child born with a birth defect. I succeeded in legislation that now means that if you have had a cesarean section, you can be turned down for health insurance. That you can be turned down if you have asthma. It was my litigation that achieved this result. I want to tell all the senior citizens of my state that the litigation that I brought meant that you are now going to have a sharp and drastic increase in the price you're paying for prescription drugs, because the closing of the donut hole in the coverage of prescription drug costs was invalidated today by the Supreme Court. And finally, to all of those people who are families who have a child under the age of 26 who is now in treatment for an illness, today you lost your right to have that person included within your insurance coverage. I just think that would be astounding. The fact that people only think this is about the quote mandate unquote is astounding, but if it were struck down, the story would immediately be dramatically different. Dramatically different. It would be a story about all of these consequences for families with children under the age of 26, for senior citizens, for those who are going to get coverage because they're in the hard-working poor. I think the consequences would be quite dramatic, and how Congress could somehow get itself together to repair some of this and get legislation through both houses, I think would be far more of an extraordinary train wreck than anything we have, than anything we could easily now imagine.
Either of you want to address that question?
Just briefly, it's particularly with this Congress. I mean, it's the most polarized Congress you can imagine. They're not going to come together and agree on anything. And I do think that if there's no question that the reason why it wasn't contemplated is there's no question that healthcare and the healthcare industry comes under the Commerce Clause. And they keep framing the question differently by saying, but you're forcing people into commerce. But again, you're not, because they're already in commerce. They're just not paying for it. We are. And so it's, I think that every piece of legislation would be reviewed, and it would be under a microscope, and they have to look back. It took them 70, 80 years to get here. They rejected a national payer system. They rejected other single payer systems. They rejected a lot of other alternatives to come up with this alternative. Whatever they did to resolve this issue, and the issues that Walter mentioned are real and I mentioned are very real, would then again be challenged by definition, because it would be some kind of other creative nuance that somehow makes this a case of first impression, which it really isn't.
The only thing I would add is that what this really represents is the politicization of the court. I mean, so I had a cab driver yesterday, and he had the great news on. I said, have you been following the Supreme Court arguments? And he said, yes. And I said, so what do you think? He said, 5-4. I mean, you know, that.
Those DC cab drivers, so they're
Okay, so maybe I was going to elect him for Congress. And he said 5-4. I mean, you know, in other words, everyone understands this is fundamentally ideological. It's not judicial. It's not about the constitutional law. It's ideological.
Yeah. Hi.
Yes, my name is Stephen Spitz, and I just want to take off from what you just said. I was struck in yesterday's argument by Justice Scalia's question, are all 26 of these states headed by Republican governors? And whether or not, and that was replayed, by the way, this morning on C-SPAN as one of their featured points. My question is, would this likely help get Justice Kennedy and Justice Roberts to think that they don't want to have the cab driver be saying that? And in other words, that if the court actually did what the cab driver is expecting, that would hurt the court, get the court involved in a fundamentally political as well as economic decision-making process that a court should stay away from.
I'll just take that first. So they should be worried. So Bush v. Gore, Citizens United, and now this case. I mean, the point is it's also cumulative. So it's not even just this case. I mean, part of this is the perception of the Roberts court. So my hope is they would be concerned about it. I don't know if that's the way it'll come out, but I think there's a real credibility for the issue for the court.
Yeah, and I think there's actually, somewhat ironically, if they were to come out against it, I think that would help, if you sort of look at the raw politics, it would help the president in his re-election. Because people would be really upset for the reasons that Walter mentioned, and think of that as a pretty, you always say here in presidential elections, the most important thing they're going to do is pick Supreme Court justices. And people will look at this as a political decision. And I think it would actually have the opposite effect that many think would have. In terms of the Attorneys General, I'm actually the president-elect of our association of NAG, the National Association of Attorneys General. And it was interesting in the last election how for 100 and some odd years, attorneys general were really seen as apolitical when we worked with each other. The tobacco case is an example, and even the recent mortgage foreclosure agreement was another example. But this healthcare deal was it's a raw political deal. I mean, I can guarantee you, except maybe one or two, that not one attorney general that signed on to those 26 states read a word of the Affordable Care Act, which is this big. Most people haven't. And yet they signed on because they were told that's the politically expedient thing to do. So I do think that it really will have the effect of politicizing the court. That said, there's an enormous amount of respect for the Supreme Court and its decisions in this country. Bush v. Gore was one of the most tortured decisions in the history of the Supreme Court, and it had directly affected who's going to be the next president of the United States. Yet the transfer of power, unlike in some other countries, occurred without one bullet being fired. Both of them were up there at the inauguration. And so people respect the decision. They'll respect this decision. There'll be a lot of outcry.
Next question.
I just want to make a quick historical note. Oh, is this on?
Oh, there you go. I just want to make a quick historical note. My name is Kristen McGraw. I'm from Virginia. That 75 years ago today, March 29th, 1937, marked the famous switch in time that saved 9. And who was the famous switch? Justice Roberts. Owen Roberts.
Wow.
Thank you. That is a useful
Another
tidbit.
question that'll next. This question right there.
I'm Paul Ramshaw. Is there a way, if we had a constitutional convention and we were redoing things, is there a way we could try to prevent this from happening in terms of how we pick the justices or what we allow them to decide?
Walter?
Yeah. I think you could probably get a substantial consensus really across political lines if we were doing it again, that there ought to be, justices should be appointed and independent and not removable, but for a period of, say, 15 years. One of the things that would do would be to counter the incentive of presidents to name justices who've not yet had their first midlife crisis. I think it's too young to be on the court, so that it would be perfectly fine to appoint someone who was 60 years old, who, like Justice Powell was, but not appointing 39-year-olds. And I think that would be a graceful way to do it. I think that would be a big difference. It is slightly off topic, but this wonderful, how do you do that? This wonderful example of this is the date of the switch in time. I just want to note that 47 years ago today, Professor Thomas Emerson of the Yale Law School stood to the podium of the United States Supreme Court to begin his argument in Griswold versus Connecticut on behalf of Planned Parenthood of Connecticut. 47 years ago today. I'll have more to say on this subject on June the 7th, which will be the 47th anniversary of the decision in Griswold.
Wow, well, those are, I'd have to say, two very important historical notes that I hope have some bearing on what happens with the court today. Are there any other questions? It's David.
The one thing no one has talked about so far is the length is the Medicaid case, and just to some extent, to my mind, the suggestion that the spending power doesn't allow the Congress to extend the Medicaid program is significantly more radical than the Commerce Clause question. So I was wondering if someone who has read the transcript, which I have not, wanted to talk about that.
It is almost unimaginable that the court would strike down the expansion of Medicaid. And yet, there were certainly justices who appeared sympathetic to that argument. I say it's unimaginable in that, working on the brief I did for the congressional Democratic leadership, it becomes clear that there's just no judicially manageable standard. In addition to, I think, a decision would be hard to defend on its own grounds. It would lead the court into political terrain and policy terrain, I think, in a way that it has never done before. The question of whether something is coercive or not, turns out at bottom to be a very normative question. That is, are people being offered a program and put to a choice they ought not to be put to? This is essentially a completely normative and policy question at the heart of this inquiry. That's why, although the court has said that some conditions on spending may be coercive, it's never actually invalidated a federal spending measure on this grounds because of the utter lack of any coherent stopping place or means or judicially manageable basis for resolving the questions, other than we think the state shouldn't be offered this particular choice or that particular choice. It seems to me that if the court were to strike down the Medicaid expansion, the House and Senate should just send their keys over across the street to the Supreme Court and say, you're in charge now of appointing us, passing legislation, all the policy choices, about what the bases for federal spending should be are obviously going to be yours. Just go ahead and make them. We're all going home. Let's, we might as well just have save everybody a lot of time by having the Supreme Court make all the decisions in the first instance. I want to know one thing before we go, is that I think that Solicitor General Verrilli's closing and the end of the Medicaid argument was one of the finest moments I have ever experience in Supreme Court advocacy when he asked to take a step back and to note that the Medicaid expansion we're talking about this afternoon, the provisions we talked about yesterday, we've been talking about them in terms of their effect as measures that solve problems in the economic marketplace. But there is an important connection, a profound connection between that problem and liberty. And I think it's important we not lose sight of that. That in this population of Medicaid eligible people who will receive health care they cannot now afford under this Medicaid expansion, there will be millions of people with chronic conditions like diabetes and heart disease, and as a result of the health care that they will get, they will be unshackled from the disabilities that these diseases put on them, and thus have the opportunity to enjoy the blessings of liberty. In a very fundamental way, this Medicaid expansion, as well as the provisions we discussed yesterday, secure the blessings of liberty. This will be true for a husband whose wife is diagnosed with breast cancer and who won't face the prospect of being forced into bankruptcy to try to get care for his wife and face the risk of having to raise his children alone and not going to multiply example after example. He talked about the judgments that Congress made, and then he says, maybe they were right, maybe they weren't. But this is something about which the people of the United States can deliberate and they can vote, and if they think it needs to be changed, they can change it. And I would suggest to the court, with profound respect for the court's obligation to ensure that the federal government remains a government of enumerated powers, that this is not a case in any of its aspects that calls that into question. This was a judgment of policy that the democratically accountable branch of this government made by their best lights. I thought it was just a powerful ending to pull back after the somewhat often frivolous and sometimes callous comments that had been made from the bench, to pull back and see this in that broader perspective. I thought was a very fine moment in appellate advocacy.
I think we might have time for one more question if there's one more. But if not, then I don't know if the panelists have any additional comments before we close.
It's hard to follow that one, but I just have one. I'd like to reframe broccoli. And so I think that we should all show up at Justice Scalia's house with several truckloads of broccoli and tell him that we all need broccoli.
Thank you. Well, let's collectively thank our panelists for a great discussion.